Proposition 1, legal language is a bird of paradise. Why do I think that legal languages are so special that I call them a bird of paradise? Let's go back to the very beginnings of linguistics, where the famous Swiss scholar Ferdinand de Saussure introduced us to one of the basic principles how languages work. Languages work in a way that we have a relationship between an object and the label that describes the object. Let's take a look at one example. Let's suppose that we have this thing here that you all know, that you all have, and we put a name on it. The name would be phone, right? So we have a thing, and we describe this thing by the use of the word phone in English. When we want to use French as a communication tool, we would use the French name for this. When we use the Japanese language, we would use the Japanese label for it. So there's this relationship between the signified and the signifier, the label that we put onto things. This is how ordinary languages work. What about special languages? Well, special languages, such as, for example, the medical language, would work along the same lines. When you suffer from a heart attack, a condition of your heart, we have a label for that in Japanese, in German, in English, you name it, you got it. But what about the law? Well, interestingly enough, with the law, things are not that easy. Things work differently. Let me give you an example. And let's start with a term that we find in both the German as well as the Austrian legal system, the term Gewährleistung. When an Austrian lawyer thinks about this term, automatically he or she would think of a lot of things, such as statutory provisions in the Austrian law, case decisions from courts, legal writing, European statutory law, European case decisions from the European Court of Justice, and legal writing as well. So all of this taken together would create the overall impression, the overall meaning to an Austrian lawyer. When you present the very same term to a German lawyer, he or she will have a completely different understanding of it because he or she will think of German statutory provisions, German decisional law, treatises, and so on and so forth. Hopefully the European part will be the same as in the understanding of Austrians. So we can tell by this example, or from this example, that even though we have the very same label, the very same name, we are matter-of-factly describing something different. Now, this applies even more so when you leave your family of jurisdictions and you go to a different jurisdiction, such as the English or the American jurisdictions. There again, related terms such as warranty, guarantee, etc., will have a different meaning and will have a different content when it comes to a description of what they stand for. This is what makes it so fascinating to talk about legal languages, because they don't follow those simple rules which have been explained to us by de Saussure. If you want to learn more about this, go to the next explanation, go to the next proposition, or check out our courses.